to whether this act will prevail, or it is in conjunction with the other acts, or whether it is in derogation with the other acts. What will be the situation, and what are the purposes of the amendment, and how various judgments, including N-SWIFT, etc., have proceeded the legal journey in this act, which we are talking lot about, especially as to whether there are differences regarding the insolvency and how there is a difference between the bankruptcy, and what is the way forward. And like on the previous session when we had with Mr. E. Om Prakash, the senior advocate from Madras Bar Association, he informed us the various aspects and as to how the Companies Act, etc., had been diluted, and as on today, all proceedings would proceed under the Insolvency and the Bankruptcy Act. His session had already been well received, and since we know that he expresses the things which is easily to be understood, and a topic which normally we do not have in the syllabus of the law universities and law university and colleges, but we knew that the speaker could make it understand even to a person who is hearing it for the first time. Consequently, when we became the knowledge partner with GemTech College of Noida, a very esteemed college for the purposes of law, engineering, and other aspects. But as on today, we are connected on the perspective of law. We have Ma'am Palvi Gupta, the head of the department of the college and the institute. Before we request Mr. Om Prakash to take things forward, I would request Ma'am Palvi Gupta to share her insights regarding the college itself, since we are going live on Facebook as well as on the YouTube. Coupled with welcoming Mr. E. Om Prakash, it's always a pleasure connecting him off the platform and on the platform. Over to you, ma'am.
Good evening, Vikasji. Thank you very much for sharing your platform. First of all, I would like to introduce my college. GIMS School of Law, Greater Noida. Official name of this college is GemTech School of Law, GIMS Engineering Management Technical Campus. It was established under the GIMS Educational Group. It has two universities in Jaipur and Bahadurgarh. It has various management colleges in all four corners of Delhi. It is a very pride admissions in management. Now it is an extended campus in Greater Noida. Here they are offering various courses in engineering, B.Ed, BCA, BCom, and law also. We have very bright students in law. Although it's a new college, but we have very bright students. Our student has participated in various national and international moot court, and we have conducted three national moot court. And our students had, we can say, our alumni are selected in DALSA. They are working as a research scholar in also as well, and various top firms. And we are looking ahead that someone will be in judiciary in future. Now, I would like to welcome our eminent speaker, E. Om Prakash ji. E. Om Prakash has done his bachelor degree from Madras Law College, and he has practiced in all the matters, whether it is a civil matters, commercial matters, writ petitions. He is working efficiently in high courts and various Supreme Court and various tribunal as well. Uh, uh, Advocate E. Om Prakash has done work with various eminent law firms in all the sector, public sector, banking sector, private sector, in all the institutions. So I welcome E. Om Prakash ji over here to address this gathering to our participants, our students, and I welcome once again. Over to Vikas ji.
Thank you, madam. Thank you, Mr. Vikas. I'm happy to be part of this session again in one of the nice evenings. The other day we had some thoughts on Insolvency and Bankruptcy Code. In fact, I tried to take you through the entire scheme of the code as it unfolds and pointed out as to certain niceties which are there. You would recollect when we spoke about Insolvency and Bankruptcy Code, a modern law, there was references to financial creditors, operational creditors, how the earlier regime has changed in terms of the creditors being put in control and therefore the committee of creditors having a primacy in their say. And other than that, we had also pointed out that the code seeks for working towards resolution, and on failure of resolution, looking at a liquidation with an object of maximization of the assets of a corporate debtor. We had also looked into the very important aspect of the code that it is sought to be driven in a time-bound manner. So with all these backgrounds, now today we will look at what kind of amendments have come to this code. When we speak about amendments to Insolvency and Bankruptcy Code, two things are of importance. One is that though the Act came into force in the year 2016, before 2020, that is within a period of 4 years, there had been certain essential amendments brought about to the code, and which were mostly driven because of certain decisions by the court or certain interpretations which had come into place. And it was also in the context of certain difficulties which were faced. So therefore, the code had evolved itself with the march of law, and in the speed in which the amendments were brought about and it got implemented is something which we had not seen in the past. So these would be the essential things. So when we speak about amendments, I would primarily like to point out to you that what Supreme Court had said about the amendments to this code. Please see this judgment of the Supreme Court in the case of Swiss ribbons. You are aware that the Supreme Court upheld the code in the case of Swiss ribbons versus Union of India, reported in 2019 for SEC page 17. Now, while upholding this code, in one of the paragraphs at paragraph 85, Supreme Court had the following words to say. We have also seen that the working of the code is being monitored by the central government by expert committees that have been set up in this behalf. Amendments have been made in short period in which the code has operated, both to the code itself as well as to subordinate legislation made under it. This process is an ongoing process which involves all stakeholders, including the petitioners. So therefore, while upholding the enactment, Supreme Court had an occasion to consider as to how these amendments were taking place in making the code a vibrant law. So in this context, for today's session, I'm just looking at pointing out to you certain specific areas where these amendments had happened. For the said purpose, I will just put out as 10 different topics and thereafter take you through how there was a necessity for an amendment in respect of each of this aspect, as well as what was the background litigation on this matter. And post that, we may also run through by way of a PowerPoint presentation as to amendments in each of these sections. Now, coming back to the subheadings for the day, or the areas which we are going to look as to where the amendments have come to the code. At the first instance, you can find the amendment was brought in the concept of financial creditors. Rather, the home buyers of real estate properties were treated as financial creditors by virtue of an amendment which was brought to the code. So the first topic would be home buyers as financial creditors. Then you can look at amendments which came in terms of timelines which were fixed under the code. As you know, section 12 of the code makes it very clear that the entire process has to be completed within 180 days. And as I pointed out to you the other day, there is a provision for a further extension of 90 days. And beyond that, by virtue of an intervention of the Honorable Supreme Court, an amendment was brought in, bringing about a outer limit of 330 days. So therefore, in terms of timelines, now on these timelines, what are all the amendments and how the code tries to drive it will be the next area which we are looking at. Then thirdly, we will look at the resolution process. In the resolution process, you will have a person called a resolution applicant who steps in by submitting a resolution plan and taking forward for an easy resolution of the insolvency situation of a corporate debtor. Now in this, the amendment came in terms of an ineligibility being prescribed to a resolution applicant. So that was one major amendment which came. Then you had cases of claims being operational creditors. As you are aware the other day, which I pointed out, in case of an operational creditor who seeks to initiate this corporate insolvency resolution process, he has to give a prior notice. Under Section 8, it stipulates that a notice has to be given, giving a particular time limit before which the corporate debtor has to come forward to answer the claim. Either he satisfies or he points out that there is a pre-existing dispute. Now, this aspect had gone for a consideration before the Honorable Supreme Court. I will point out to the judgment. So therefore, the next amendment was on the point of this pre-existing dispute in the claim of an operational creditor. Then you had amendment bringing about a provision as to withdrawal of an application. Once a CARP has been initiated or commenced, is there a scope for withdrawal? This came about by virtue of an amendment which was brought to the code. Then you have amendment which spoke about whether the moratorium can be extended to the personal guarantors. This again was a fallout of a judgment of the Honorable Supreme Court on a particular case where personal guarantors also sought to get a protection by a moratorium declared under the CARP process. So therefore, the amendment was on the point of moratorium for the assets of personal guarantors. Now, having said this, as I pointed out, though the individual insolvency has not yet been notified, but a notification has come as regarding insolvency against personal guarantors, individuals being personal guarantors to a corporate entity. So that amendment is also there. Then you have an amendment in respect of MSME role in a resolution plan or the MSME implications in terms of the provisions of the code. As I said, there was a provision by way of an amendment regarding ineligibility to be a resolution applicant. So this ineligibility was sought to be excluded in terms for the MSME companies. So that was an amendment which brought about. Then you had amendments on the voting thresholds. The code initially prescribed certain voting rights or certain resolutions to be passed only if there is a particular percentage of vote being casted in the COC. This was revised. So there were amendments on the voting threshold. Then you have an amendment by an insertion of a provision on the suspension of the initiation of CARP. This is directly a fallout on account of the COVID impact. Then lastly, we will look at the amendment rather by way of a notification by the central government on increasing the threshold. As you are aware, when the code came into place, when it was implemented, the original threshold limit was any debt above 1 lakh. Now that has been amended, now making it 1 crore. So this came by virtue of a notification in terms of a enabling provision in the Act. So this will be the background as to what are all the areas which we are looking at as to how the amendments have set in. As I had pointed out earlier, this had been a robust enactment where within a short period of time, every other issue which was coming up for consideration was being addressed either by way of an interpretation by the court or amendment being brought about by the legislature. Most of these amendments were driven in terms of decisions of the Supreme Court setting out the march of law. Then amendments, when it were made also to the provisions of the Act, rules, as well as regulations. And as I pointed out, one important, the threshold limit came about by way of a notification. Now with this, let us get into the first area of amendment, namely the topic on home buyers as financial creditors. As I pointed out to you, by a definition under Section 5, the financial creditor is defined, a financial debt is defined. More particularly under Section 5, subsection 8, the financial debt definition is provided. Now what had happened is after the code started spreading out, rather more of CIRPs being initiated against corporate debtors throughout the country, a peculiar situation arose where these development companies, the real estate companies which were in the business of developing either huge residential properties or huge commercial properties, were also brought under the CIRP, either at the instance of the financial creditor, namely the banks and financial institutions who had to recover money, or at instances by the operational creditors, who are basically suppliers of goods or who are rendering services to the corporate debtor. So once this had come into place, as far as these companies are concerned, there were huge home buyers, people who have invested their hard-earned money with a hope to get a flat constructed and delivered to them. Now, they had difficulties because they could not fall under the category of a financial creditor, or they could not fall under the category of an operational creditor. So initially, an issue came up as to what claim form they have to file. As I told you, under the regulations, the specific forms are provided. If it is a Form A for financial creditor, Form B for operational creditor, likewise. So an issue came up and it was taken up with the IBBA and they sought for some clarification. It was said that you come under the other creditors. Now, being other creditors, what had happened is that they were not able to be fit into, they cannot initiate CIRP at the first instance. They cannot be part of the COC. So this difficulty arose. Therefore, one of the home buyer, namely Chitra Sharma, had petitioned the Honorable Supreme Court by way of an Article 32 petition in the case called Chitra Sharma versus Union of India. In that case, which is concerning the JP Infratech Limited, the Honorable Supreme Court noticed that home buyers, being other creditors, could file claim but could not initiate CIRP or participate in the COC. So therefore, subsequently, Supreme Court passed its orders requiring that the interest of the home buyers be safeguarded, and in fact issued interim directions in the pending matter, directing the resolution professional at the particular company to consider the claims of the home buyers as financial creditors, and they, being in big numbers, had also passed an order that they shall be represented by a authorized representative. This case ultimately came to be disposed of and reported in 2018, 18 SEC 575. Now, this decision, or whatever process which it was going through when pending before the court, had necessitated the second amendment to the code, which included home buyers. Now, interestingly, they did not make any major changes in the provision. They did not bring about a special class of home buyers as a definition or anything. What the legislature did was, in section 5.8, which defines financial debt, they brought in an explanation. Explanation said, for the purposes of this subclause, any amount raised from an allottee under a real estate project shall be deemed to be an amount having the commercial effect of a borrowing, and the expression allottee and real estate project shall have the meanings respectively assigned to them in clause D and ZN of section 2 of the RERA. So therefore, by virtue of an explanation, they brought within the ambit of the definition of a financial debt, and therefore a person who is entitled to recover a financial debt become a financial creditor, and therefore their claim as a financial creditor, and ultimately they were entitled to be considered in the COC. Now, this explanation which was brought in was subject to, again, a dispute before the court as to whether it will have a retrospective effect or prospective effect, and as to how, to what extent the home buyers can be part of the COC and what decision-making process they can involve with. So that was the case of Pioneer Urban Land and Infrastructure Limited versus Union of India, reported in AAR 2019 SC 4055. The Supreme Court, while discussing on the section 5, subsection 8 and subsection F, being a residuary provision, said that it always subsumed within it the allottees, and that the explanation added by way of amendment is only a clarificatory position in law, being a deemed fiction. Therefore, all contentions which were sought to be raised were negative, and ultimately the Supreme Court found that a clarification is made in the law, and the home buyers will be part of the financial creditors as they are within the part of the financial debt. So this was on the first aspect. Now, consequential to that, there were amendments in terms of regulations where an issues in respect of how the representation to be came up for consideration. Therefore, the amendments came in regulations providing that these home buyers can classify as a class by itself, and such class can be represented by an authorized representative. So consequential to this, what had happened is that even a publication which is issued on the CIRP being commenced, for the real estate companies, it was a different publication to be made. More particularly, it has to specify as to claims under the home buyers category shall be made, and they are entitled to have an authorized representative representing them. So particular forms were provided as to who can be made as an authorized representative, and obligations on the RP to petition the adjudicating authority, namely the NCLT, and seek for appointment of an authorized representative for this home buyers. So all these consequential amendment flowed therefrom. So this was one first amendment which had a greater impact on the functioning of the code, as these home buyers were recognized as a class of financial creditors. Okay. There was a subsequent amendment which came also, which said that one single home buyer cannot initiate a CIRP. Now they have brought in some threshold limit, saying that at least if they qualify for a particular numbers or particular debt, only then they will be entitled to bring about a CIRP process. That I will take you through when I am taking you through the amendments section wise. Now let us move to the second amendment or second topic on the amendment. This was on the point of timelines which the code specifies. As I pointed out, section 12. Now, other than section 12, at every stage there are timelines. For example, a petition being filed before the NCLT for commencement of CIRP, either under section 7, 9, or 10, also specifies timelines. It says that the adjudicating authority has to decide the application within a period of 14 days. And if it finds that there are some defaults in the application in terms of compliances, it can return the application, but such return compliances should be made within 7 days. So these timelines were being strictly followed, and therefore some issues had come as to whether it has to be seen, whether it is mandatory or it is directory in nature. So this issue was dealt with by the Honorable Supreme Court in the case of Surendra Trading Company versus Jugilal Kamplat Jute Mills, reported in 2017, 16 SEC, page 143. There the Supreme Court said, laying down timelines sends a clear message that time is the essence of the code. Timelines have been classified as mandatory or directory. What the court held is that this 14 days period for admission or rejection of the application for initiation of CIRP is only directory. So there is no today requirement that within 14 days the NCLT has to dispose of the application. That is where you find that sometimes it takes a month's time or 2 months or 3 months and so on. But however, the Honorable Supreme Court said this provision of 7 days time to rectify defects in the application is mandatory. So if an application is returned, the petitioner has to represent it by complying with all the defects, if any, within a period of 7 days. Otherwise, it is deemed to have been dismissed forever. Now, then the Supreme Court dealt with the timeline of CIRP, namely that 180 period which is stipulated in section 12, as well as the 90 days extension which was provided under the same section by a subsection. Then the Supreme Court went on to decide on the amendment which came as regarding the 330 days statutory outer limit. So ultimately, Supreme Court in the case of Arcelor Mittal India Limited versus Satish Kumar held that a statutory outer limit cannot be extended. Then it said certain periods can be excluded from the calculation of the maximum time limit. It specifically said the time which is spent before the tribunals can be considered. So all these things were creating certain confusions, and that is where the amendment to section 12 was made, where the outer limit was fixed as 330 days, and which should include the time spent on litigations. Today, the CIRP period is set as per the original schedule in section 12 as 180. Extension can be sought for a further period of 90 days, but this can be by way of an application by the resolution professional on the resolution of the Committee of Creditors with a voting right of more than 66%. Now, such extension can be only granted once. And in view of the amendment which I pointed out, ultimately now everything should be over in 330 days, inclusive of the legal proceedings. Now, this was again dealt with by the Honorable Supreme Court in the case of Committee of Creditors of SR Steel Limited versus Satish Kumar Gupta, reported in 2019 SEC Online 1478, where challenges were made with regard to these amendments to section 12. The Honorable Supreme Court only struck down the term mandatory as being manifestly arbitrary. because by way of an amendment, when they fixed these 330 days, the legislature said that at every stage it would be mandatory. So therefore, the general rule laid down was that ordinarily the time taken in relation to CIRP must be completed within the outer limit of 330 days from the insolvency commencement date, including extensions and time taken in legal proceedings. And Supreme Court further added, exceptionally, if the delay or a large part thereof is attributable to the tardy process of the adjudicating authority or the NCLAT itself, the extension of time beyond 330 days can be granted. Now, having said this, once this amendment has come and Supreme Court has also stepped in dealing with it in one or two decisions, so therefore there was some requirement as to a guideline which is required. Because as I said, every stage there is a timeline. The 14 days by which commencement has to happen on the orders of the adjudicating authority. Then from there, within 3 days, the publication to be made. Then from there, within 14 days, the claims have to be received. Then within 30 days from the commencement, the first COC has to happen and the resolution professional has to be appointed. So go on, it goes on like the expression of interest to be done within a period. The information memorandum has to be drawn within a period. And the resolution plans have to be considered within a period. So all those things were there. So therefore, what IBBI done is that it brought about a regulation by way of an insertion, namely Regulation 40A. Now, this Regulation 40A specified a model timeline for corporate insolvency resolution process. It says that it put in a kind of a tabulation. I can just show you the tabulation as to each section and as well as regulation which requires to be looked into. For example, if you see section 16.1 is the commencement. That is taken as timeline day 1. Then regulation 6 says within 3 days of the appointment, a public announcement. So therefore, +3. Then submission of claims. It is dealt with in section as well as regulations. Then you have submission of claims on a louter limit in terms of regulation 12.2, which is 90 days. Then verification of claims. Likewise, each regulation, each section, for example, in section 21(6) capital A, appointment of an authorized representative for these home buyers. That was also to be made within a time limit. It said T+23, which means from the commencement date, within 23 days, this has to be done. Likewise, report certifying constitution of the committee of creditors. So it goes on. So every section which specifies a time limit, every regulation which specifies a time limit, the ultimate guidelines was there provided by Regulation 40A, which gave a tabulation as to at each stage what is the time limit within which it has to be done. And ultimately, it ends up with the final time limit of 180 days. Now, then there can be an extension if it is considered to be required. Then, as I said, the Supreme Court said in exceptional cases, there can be certain exclusion of period. But in any case, ultimately what is to be seen is that it can be only within the period of 330 days. So this is on the timelines, amendments and to the provision as well as the regulations, which is of some importance. Now, having said this, now let us come to the third subheading of the topic, which I said is the ineligibility to be a resolution applicant. Now, what had happened is that in this resolution process, there had been cases where companies which went through CIRP, either at the instance of the application filed by the financial creditor and some instances where operational creditor. And interestingly, some promoters or the corporate debtor themselves came forward and filed applications seeking for initiation of CIRP. What ultimately came out is that by getting into the CIRP, they were seeking to have a resolution of the corporate debtor. That far it was fine. But the resolution plans were sought to be submitted by the promoters themselves who were the reason for this default or the situation of insolvency in a corporate debtor. And a very, very interesting case is the case of a synergy dure, where prior to the commencement of this enactment or prior to the commencement of the CIRP, this company gets an assignment of a debt to its own sister concern, and from there, it gets an assignment to a non-banking financial company. And once the CIRP is initiated, shockingly, the COC members, rather the financial creditors, the banks and other institutions who had lent money, found that in terms of the debt to be recovered, this non-banking financing company was having a percentage of about 78 or 80%, 76 or so. All others put together were only 24%. So every process they were able to get it through. So therefore, the COC was immediately constituted. They had their own resolution professional, and they brought about a resolution plan, or they brought about various things which they wanted to achieve. So this led to a situation where one of the financial creditor has to petition the NCLT by series of applications. You will file application asking the first COC to be declared null and void, second COC to be declared null and void, and declare the assignments as null and void. So all these things had happened, and ultimately, when this matter came up to the consideration before the Honorable NCLAT, in terms of the provisions, NCLAT found that there was nothing wrong. So they said assignments are valid, assignments have already been held to be valid by the Supreme Court in different cases. And they said whatever assignment has happened in terms of which the non-banking finance company was a financial creditor, and they are entitled to be in the COC, and resolutions are passed in terms of the provisions as well as the regulations. So therefore, what was found is that there was a backdoor entry of the erstwhile promoters who were trying to get into the situation and get out of the defaults or whatever it is. So this led to the amendment by way of an insertion of section 29A. So the legislature brought in section 29A, stipulating a condition of ineligibility to be a resolution applicant. They primarily pointed out that persons or persons acting jointly or in concert who are intending to submit the resolution plans, if they are an undischarged insolvent, they would not be eligible. If they are a willful defaulter, they would not be eligible. And it also said that at the time of submission of the resolution plan, if such person, either by himself, be a promoter of a CD, who has an account with the bank and such account is being classified as an NPA, or the person being in management or control of the corporate debtor, which account is classified as an NPA for a period of 1 year from the date of classification till the date of commencement of CRP. So all these categories were sought to be kept away by way of declaring them as persons who are ineligible to be resolution applicant in terms of the amended section 29A, rather the inserted section 29A to the code. Of course, the section also had certain exceptions given as to where one exception, if you see, it also provided that person who are in default to the institutions, they can pay that money, pay the unpaid dues with whatever interest or whatever outstanding has on that date, and still become eligible. So these kind of exceptions were provided. So as regarding this section 29A, the Honorable Supreme Court dealt with it in the case of, again, the same SR Steels matter in the case of ArcelorMittal India Private Limited in the reported judgment of 2019 2 SEC page 1, where Supreme Court said the eligibility criteria specified under section 29 of ABC applies to a resolution applicant, and any person, entity acting jointly or in concert has to fulfill certain requirements. The Supreme Court applied a look-back approach and held that while the credentials of the resolution applicant as on the date of submission has to be considered, past actions which may be proximate and relevant to the current resolution also being considered, and that was the reason or the logic which the Honorable Supreme Court found as to the bringing in of section 29A. So this again, you will have a lot of jurisprudence which evolved this particular provision being considered in different case laws as to what will be the ineligibility to be applied. And at one point of time, this ineligibility was standing in the way of many MSME units which were seeking for resolution of their companies. And as far as MSMEs are concerned, they had a special enactment, and there was a thrust by the government to promote these MSMEs. Therefore, again, one more amendment came in terms of providing a recite to these MSMEs from keeping them away from this implication of section 29A, which I will again point out at a later. Now, having said this, the next consideration would be this pre-existing dispute in the case of operational creditor. Originally, this section 8, which said that a notice being issued by the operational creditor to the corporate debtor, and corporate debtor is required to send a reply within a period of 15 days, either stating that the amount has been discharged, or they are ready to discharge, or they're making the payment, or pointing out that there is a pre-existing dispute. And the word used in the enactment was that, and it said that pointing out a pre-existing dispute and pendency of a suit or an arbitration proceedings in respect of such dispute. Now, therefore, all these things were required. Even if there is a pre-existing dispute, it was essentially to be shown that in respect of that dispute, there is already a legal proceedings. So this came up for consideration in the case of Mobilox Innovations Private Limited versus Kirusa Software, reported in AR 2017 SC 4532. Now, the Honorable Supreme Court, referring to Section 8 of the Code, held that the dispute or the suit arbitration proceedings must be existing before the receipt of the demand notice. Now, then they went on to explain that such dispute should not be patently feeble, and it should not have only a legal argument, or it is a spurious or hypothetical or an illusory, but should raise a plausible contention which requires further investigation. So in that context, the Supreme Court went on to say that it is not only necessary that a suit or arbitration is pending, dehorse that if you are able to show an pre-existing dispute, still you will be entitled to put it across in the reply, and ultimately, if it is satisfied to the tribunal, a Section 9 application will be dismissed. So effectively, what the Supreme Court said is that and which was finding place there, a dispute, pre-existing dispute, and a suit or arbitration, that and was interpreted to be read as or. Now, this again led to an amendment. The legislature made it clear by bringing about an amendment to Section 8, subsection C, 6, where they clearly now made it that independent of the suit or arbitration, if you are able to show an existing dispute, still a petition under Section 9 will not be maintainable at the instance of the operational creditor. Now, as regarding this operational creditor, there was also one more issue. Section 9(3) stipulates that there are certain mandatory things which has to be complied if an operational creditor has to maintain a petition for initiation of CIRP. Now, one of the condition was that they have to enclose a certificate of a financial institution that there is no credits to the extent of claim being made. So this financial institution was again defined saying banks, or either the nationalized banks or scheduled banks of the country. So an issue came up as regarding a foreign banker who sought to initiate a proceedings. And therefore, it was found that they were not able to produce a certificate of a nationalized bank or a scheduled bank because no account was being operated within India. So this consideration had happened in the case of Macquarie Bank versus Silpi Cable Technologies, reported in 2018 2 SCC 674, where the Honorable Supreme Court at the first instance held that the condition under Section 9(3)(c) is only directory and cannot be interpreted in a discriminatory manner. One of the important condition precedent is an occurrence of a default, which can be proved by means of other documentary evidence, such as a letter written by the corporate debtor or to the operational creditor confirming that the particular operation debt is due and payable. So therefore, despite having sufficient evidence, a dismissal of a petition simply because a copy of the financial certificate is not available leads to an absurd result. These were the exact wordings of the Honorable Supreme Court. It proceeded to say that foreign suppliers are included within the definition of operational creditors. Therefore, you cannot exclude them. Now, this again led to an amendment being brought about in Section 9(3)(c), which ultimately used a word saying that such certificate of a banker, if available. So they added a word saying that if available to satisfy as regarding this position of law, which was reiterated by the Honorable Supreme Court. So this is on the amendments concerning the operational creditors. Now there is the next situation is an amendment by insertion of Section 12(a). This particular section provides for withdrawal of an application. Now what had happened is, in a particular case, after the commencement of the CIRP, the corporate debtor was ready to discharge the debt. They said, I have means, I will pay it now. So relieve me of this rigor of this code. I don't want to get into this. But in terms of the provisions of the code, there was no opportunity for that. Once a CIRP was initiated, it has to go through the process. So this was taken up on the hierarchy before the NCLT and NCLAT and ultimately to the Supreme Court, which is the case of Lokhandwala Kataria Construction Private Limited versus Nisas Finance and Investment, reported in 2018 15 SCC 589. The Honorable Supreme Court on 24 July 2017, before the coming into of this insertion of Section 12(a), invoked its inherent powers to enable a third option, which was to allow the promoters an opportunity to arrive at a settlement and seek for withdrawal. So therefore, in that case, in exercise of powers under Article 142, the Supreme Court passed an order allowing the withdrawal of the application, Act in fact said that it recommended that let this be also considered by the legislature, and in the meanwhile, it directed that the adjudicating authority at the first instance, before the constitution of the COC or before proceeding further, if there is a possibility of any settlement happening or payment being discharged, it can consider allowing of withdrawal of this application. So consequent to this, the amendment came, and in fact, the Insolvency Law Committee recommended that such a provision be made, but it only provided that in cases of such withdrawal under Section 12A, there should be a resolution by the Committee of Creditors with a voting of 90%. So this was made mandatory. So in terms of which 12A came into the statute book, which provided for withdrawal. And again, it followed with certain more amendments which had also happened on this. Now with this, you come to the next subtopic for the day as to amendment which was concerning the moratorium for the personal assets of the personal guarantors. Now this was again one interesting case. A company which was undergoing CARP. Admittedly, moratorium is declared in respect of the assets of the corporate debtor. Now, what had happened is that the promoters of this company who had given personal guarantees had also mortgaged their personal properties as a collateral security to the bank. Now, bank wanted to proceed against those securities under SARFAESI, and they went ahead. The promoters petitioned the NCLT and contended that if the assets are to be sold by the bank and by invoking SARFAESI, as a guarantor, he can claim a right of subrogation as against the assets of the company. So which means he said there is a possibility of an interest being created on the assets. In terms of Section 14, since there is a moratorium, there cannot be any interest. So since there is a bar of creating any interest on the assets, this action of the bank should be prevented. They should not be permitted to proceed with it. The NCLT and NCLAT to some extent agreed with such contention and held that there will be a moratorium operating also against the assets of the personal guarantors. However, when the matter went to the Honorable Supreme Court, in the case of State Bank of India versus V. Ramakrishnan and another, reported in 2018-17 SCC 394, the Honorable Supreme Court held that the assets of the personal guarantors will not be protected under the moratorium declared by the NCLT against the corporate debtor. Now, this again brought in the legislators to the forefront, and they had thought about bringing about amendment, and accordingly, amendment was made in Section 14, which speaks about moratorium, where under subsection 3, there are certain exceptions to the amendment. So there, they said in subsection 3, the provisions of subsection 1 shall not apply to. So in A, what was covered already was such transactions, agreements, or other arrangements as may be notified by central government. So they brought in a subsection B, a surety in a contract of guarantee to the corporate debtor. So by virtue of these amendments, they said that there cannot be a moratorium as against the assets of the personal guarantors. Then again, this went into further amendments and further situations as to the necessity to proceed against these personal guarantors being considered. And therefore, the consequential amendment came where the individual insolvency as regarding personal guarantors of corporate debtor came to be notified. And consequentially, even Section 2 was also amended to bring in guarantee being given to the corporate debtor by individuals as well as guarantee by corporates in the nature of corporate guarantee being given. So these were all the amendments concerning this moratorium in terms of assets of the personal guarantors, which again, as I have seen, was a consequences of a decision of the Honorable Supreme Court. Now then you will have the MSME role in terms of resolution plan, which I had pointed out when I said about Section 29A. Now, what we can do is that probably run through a kind of a presentation on each section which is considered for an amendment. I will just bring you to that. You can have a look at the particular amendments which have been brought about to the sections. At the first instance, you can see even Section 1, there was an amendment. This is with regard to the bringing into the ambit of Jammu and Kashmir. So it has not much of. Section 2, you can find the amendment was by way of an insertion in subsection E, personal guarantors to corporate debtors. Now earlier, E was only reading as partnership firms and individuals. So they made as a separate class a personal guarantors to corporate debtors, so that this particular area was notified and insolvency is being proceeded against these individuals who stand as personal guarantors to corporate debtors. So that is the amendment to section 2. Now section 3, some small consequential amendment. Interestingly, if you find section 3 on definition subsection 12 and default, original provision was, it said repaid. So that was amended to not paid. Then similarly, 5, again in section 5 definitions, 5 capital A was brought in, defining corporate guarantor. Then section 5 definitions financial debt, which I explained, the explanation was brought in for the purpose of bringing in the home buyers within the fold of financial creditors. Then you will find an interim finance provision was made. This has not yet been notified by the central government, though definition is brought about. Similarly, when I pointed out the debt default, which said repaid was amended as not paid. Now here you will find, in case of operational debt, the original term used was repayment. That was amended as payment. Then in section 5, there was one important amendment which came in the definition clause, namely section 24A was inserted, which speaks about related party. This had a huge consequences in terms of 29A disqualification and other disqualifications, everything. So various parties were brought in within the definition of these related parties. Probably you can go through that section 24 capital A, which was brought in. Then in definitions itself, you will have resolution applicant. So originally a resolution applicant was said means any person who submits a resolution plan. Now this was expanded, saying means a person who individually or jointly with any other person submits a resolution plan. So this was the amendment which was brought in. Then in section 7, as regarding initiation of CIRP by the financial creditors, originally the provision was financial creditor, other financial creditors. So that was expanded, saying other financial creditors or any other person on behalf of the financial creditor as may be notified by the central government. So these amendments. Then section 7, again, you will find this definition as regarding home buyers, where, as I pointed out, now the proviso says that referred to in clause A and B of subsection 6C of section 21, an application for CIRP can be filed jointly by not less than 100 of such creditors in the same class, or not less than 10% of the total number of such creditors. So a class action was brought in. Today, one single home buyer cannot go and initiate a CIRP, though he may be a financial creditor in a class. So this amendment by way of provision to section 7 provided for that. Then you will have section 9, which I pointed out. The highlighted portion you can find. The certificate from the banker, if available, is the words which were used by an amendment to avoid that situation, which was explained by the Honorable Supreme Court. Then in the same section 7, about the process, this time limits, which I said, 14 days, within 14 days it has to be done, where Supreme Court said that mandatory is not proper. They have in fact struck down the word mandatory, and 14 days they said directory. Now proviso was brought in by the legislature, saying that if an order is not passed within that 14 days, then it shall record reasons in writing for the same. So this is the proviso in section 7. Then in section 10, the amendment was in terms of initiation of CIRP by the corporate debtor itself. So earlier it said if they are able to furnish the books of account and such other documents relating to such period as may be specified, and naming a resolution professional. Now by amendment, what was brought in is that there is a requirement of a special resolution being passed by the shareholders of the corporate debtor, or a resolution passed by at least 3/4 of the total number of the partners in case of LLP, as the case may be, for approving filing an application. So therefore, if the corporate debtor today has to initiate a CIRP, apart from satisfying all other requirements, there is a requirement of a resolution by the shareholders, which, you know, if it is a special resolution, it can be happening only by a general body meeting. Then section 10A is an amendment which is of some consequences, which I said is a direct effect due to the COVID situation. 10A said that notwithstanding anything 7, 9, 10, on or after 25th March 2020, there shall be no application for initiation of CIRP as against a corporate debtor for a period of 6 months or such other period. Now, in terms of this section 10A, you are aware there is a notification by the central government initially providing a period of 6 months. And thereafter, in September, there is yet another notification which has been made extending till December 2020. So this is the amendment which was directly related to the COVID effect. Then, as I pointed out in section 12, the time limits, which specifies the extension which can be sought beyond 180 days has to be by a resolution. So for another 90 days. So in that resolution, the original voting percentage was 75%. By way of an amendment, it was made as 66. So likewise, time limit, this 330 days which was provided by Proviso is again in section 12. Then section 12A, which I pointed out as regarding the withdrawal of application, where you will find 90% of the voting share of the committee of creditors is a prerequisite. Then 14, moratorium. As I pointed out, in the moratorium, certain licenses and permits were allowed to be continued. In fact, this was again a fallout of a decision of the Honorable Supreme Court in the case of Embassy Property Private Limited versus State of Karnataka. That was a case where during the CIRP, a mining license was withdrawn by the state. That was challenged. So though the issue was different, the Supreme Court said in cases of public law, so there was a likelihood of a small issue coming up. Therefore, the legislature stepped in, the government stepped in by way of an amendment. It brought in an explanation which said that all permits will continue during this period. Then again, moratorium, as I said, these periods which are there. So in 14, there had been substantial amendments covering the surety in a contract as regarding the personal guarantors. Then in 16, appointment of IRP, the interim resolution professional, there is a requirement as regarding the tenure. Within 30 days, a resolution professional has to be appointed. Under the original provisions, the adjudicating authority on passing an order for appointment of resolution professional has to communicate the same to IBBA, and there was a requirement of a concurrence from IBBA. So this was taking time, and there was a period when it was in a limbo as to who will continue to manage. So therefore, these amendments came in 16, which provided that till a resolution professional is appointed, the IRP can continue and he has to ultimately hand over. And likewise, it also provided that if the interim resolution professional is continued as a resolution professional by the decision of the COC, there is no requirement of an application or an order by the NCLT. What is required is only an intimation to be given. So this was on section 17. Now section 16, I'm sorry. Section 17 in respect of management of the corporate debtor by the interim resolution professional. So what was brought by way of an amendment is to ensure compliances with all laws and regulations. This included in cases of filing of annual returns which were in default for years together. It was now become an obligation of the IRP to ensure all these things are done. Likewise, in section 18, when they spoke about duties, now it also provided that the assets which have to be taken custody, their amendments were brought in saying that assets of third parties which were held by the corporate debtor they are holding for some purpose. So these assets will be excluded as a case of a bailment. So likewise, the explanation also provided that the government can notify certain transactions which should be away from this, or certain assets which has to be away from it. Then section 21, which speaks about committee of creditors. There again, you will find amendments which are brought in, specific inclusion of section 524 related parties within these definitions. Now, a related party, though he may be a financial creditor, though he may be part of the committee of creditors, he will not have his voting rights. He cannot have this. Then again, section 21, you had other amendment which was brought in terms of committee of creditors. Then definition in terms of financial debt, again in section 21. Likewise, this threshold voting rights which were revised. In section 21, the committee of creditors, they had certain resolutions to be passed, originally which was 75%.
Sir, could you stop the annotation because somebody is scribbling on the screen, though I will request him also not to scribble.
I have to stop the annotations.
Yes.
1 minute, let me look at it.
First, you clear this user rubber and then stop these annotations.
Yeah. Okay, let me continue. Okay, in section 21, again, this threshold voting right was reduced. Most of the cases which were 75% were brought down to 66, and in case 75 is brought down to 51. Then appointment of resolution professional, earlier it was by 75. This again, you can find that there was one judgment there was one case which traveled up to Supreme Court where you will find 69% were the financial creditors in terms of banks, and there were 31% of the home buyers. So they were not able to agree upon a resolution professional. So there was a stalemate which was continuing. Now all these things is now being addressed because the voting percentage rate has been brought down to 66. I think it is now screen. 1 minute, I'll just try to remove this. I think it is freezed. The screen is not moving.
Yes, sir. What are you saying?
I got stuck with the screen.
You can start it again. I will just start it again. Yeah, now try that.
Yeah. So I will again try for that. So I was just trying to take you through the section-wise whatever amendments which have come. So let me just explain to that. Now section 22, as I said, the voting threshold was reduced. Then in section 23, which speaks about conduct of the CIRP process, amendments were brought in, bringing about more obligatory roles of the resolution professional. Then the approving criteria, again, the voting threshold was deferred. Then voting rights of the authorized representatives of class of creditors, as in the case of the home buyers, a specific provision was brought in by way of section 25 capital A, which speaks about rights and duties of authorized representatives of financial creditors. Then in section 27, which speaks about replacement of resolution professional, here again the voting threshold from 75 was revised to 66. Then in section 28, which speaks about approval of COC for certain actions by the RP, the original voting threshold was 75%. This was again reduced to 66. Then 29A, persons not eligible to be resolution applicant, which I have already explained to you. Then in section 30, which is on the submission of resolution plan, the amendment was brought in, making it mandatory that a person who submits the resolution plan has to file an affidavit stating that he is eligible and that he is not debarred under section 29A and he is eligible. So a self-declaration was brought in, which the RP was required to examine. So before he takes it to the COC, RP has to examine whether it is affected by section 29A or not. Then again on section 30, submission of resolution plan, it also considered as regarding payment to be made. Then 30, on the submission of resolution plan, you had minor amendments which came about basically on the voting threshold, which was revised from 75 to 66 on the approval of the resolution plan by vote. Similarly, it also provided that the eligibility criteria specified has to have a particular period. Then in 31, as regarding approval of the resolution plan, where we petition the adjudicating authority to consider in terms of the resolution of the COC. Here again, in terms of liquidation, section 33, as well as appointment of liquidator, this voting threshold was reduced. Then ultimately, you can look at a major amendment was section 238 capital A on limitation. This was again based on the decisions of the Honorable NCLAT as well as the Honorable Supreme Court as to whether limitation applies and from when it applies, because there were some conflicting judgments which arise. Then finally, it was section 240 capital A, application of this code to the micro and small MSME, where it specifically said, you can find that the ineligibility to be a resolution applicant provided in section 29A was revisited as regarding the MSME units. The provision in fact said, application of this code to micro, small and medium enterprises, notwithstanding anything to the contrary contained in this code, the provision of clauses C and H of section 29A shall not apply to the resolution applicant in respect of corporate insolvency resolution process of any micro, small and medium enterprises. Then subject to subsection 1, it also said that central government may, in public interest by notification, direct that any of the provisions of the code shall not apply. So it also provided that by notification, the central government can also consider. So this was the seventh area of amendment which I was just pointing out at the initial stage as regarding the role of MSME in resolution plan, which is brought about interestingly, by a specific provision under Section 240A. Then you have these voting thresholds. I took you through the different sections where these amendments were brought in from revising it from 75 to 66, and some cases from 66 to 51. So all this voting threshold had undergone amendments based on the experience the courts had when specific instances were brought before them, when the object of the code was being stalled on account of these issues. Now, finally, you have this suspension of the initiation of CIRP, which I pointed out, Section 10A, which is directly the COVID impact, and central government notification has come extending this further to the period. Now, finally, the last of the topic for the day would be this increase in the threshold. As I said, Section 4 of the code says that this part shall apply to matters relating to insolvency and liquidation with a minimum amount of default is. This is after following is the original provision was 1 lakh rupees. Now, this was amended with effect from 24/3/2020 to 1 crore rupees. So, this amendment is only by notification because the provision itself, proviso to Section 4 says that the central government may by notification specify the minimum amount of default of higher value which shall not be more than 1 crore. So, since a proviso was there was no requirement of any amendment to the statute. By way of a notification, it had referred to that. So, this is the sum and substance of the amendments which we can look at in the IBC. I had given you an outline as to amendments on a topic wise. I had also pointed out to amendments in section wise. So, in whole, what you can find is that there had been a driving thrust. As and when the issues came up before the court had also rose to the occasion in deciding the matters and pointing out that these are all the areas which require consideration. Likewise, the legislature stepped in and brought about the amendments. So, this makes the enactment a robust code. This makes the march of law very, very interesting as far as this Insolvency and Bankruptcy Code. And that is the reason I thought we will have a separate session on these amendments to the IBC. Thank you very much. Thank you for having spent this time with me. And I welcome any kind of suggestions or clarifications which you are looking at.
In fact, I just received the message from Ma'am Palvi to share the PPT. I've sent her the message that I will share on the WhatsApp group.
Yeah.
Yeah. Abhishek says MSME role in resolution plan.
MSME role in resolution plan. As you had signed that there is a thrust for these MSMEs to revive itself. So in that thrust, though originally in terms of Section 29A, an ineligibility was brought in for promoters who are facing defaults, be it a willful defaulter or their accounts being NPA. Now that was sought to be addressed as far as MSMEs is concerned. They were given the primacy that this 29A ineligibility will not apply in terms of that. So therefore, they are entitled to have the resolution plan submitted and to be considered.
Then the next question is by Rajesh. Was the amendment enhancing the limit to approach the IBC from 1 lakh to 1 crore is a regressive step? What is your take?
See, as on date, at the time of the notification being made, two things were in consideration. One you can look at is that there were huge number of cases which were getting filed. So the NCLTs were clogged with a lot of matters which were requiring for CIRP. So therefore, the government probably thought this 1 lakh was a very less threshold. And that is the reason where very many operational creditors were also petitioning the NCLT for initiation of process. So to give a clearance to that, the legislature, the government might have thought that let us have a higher threshold so that there will be a focus on the companies which actually require a resolution. And secondly, as you are aware, by that time, we were almost in the stepping area of this COVID situation. So there was some thoughts that there is a requirement of some receipt to be given for small companies to function by themselves and not get into this kind of situation of insolvency resolution. So it was a step which was required at that point of time. It can be always revisited because, as I pointed out, proviso gives all the powers to the government at any time by notification to change it.
This is V. Rajeshwari. Regarding limitation as per Apex Court ruling, the limitation to initiate action under IBC is 3 years. When we have more limitation period over other laws, example 12 years under the SURFACI before creditors proceed under the other law. If resolution plan is approved, what is the position of secured creditors whose claim is time barred under IBC?
One point is that limitation as regarding initiation of CIRP. See that you have enough judgments. In fact, some conflicting again. NCLAT had dealt with it. Then again, it goes to Supreme Court. Then 1 or 2 judgments in spite of Supreme Court. Again, NCLAT has decided. This you are aware of. So this is one area of limitation in initiation, where they had pointed out that as far as this code is concerned, what is of primary importance is that the debt and default. So therefore, the default when it arose, whether your debt continues to be live for the purpose of recovery is different. The debt as it is being on default for the purpose of initiation of IBC. Now the second part of the question is that as regard what will be the position of secured creditors, so far as you are able to establish your claim, then you are within the purview of the resolution plan or within the purview of COC. That is not in dispute. What is in consideration is that the initiation of CIRP, the creditors filing an application under section 7 or the operational creditors filing an application under section 9. And there, when the debt default occurred, and from there, whether it is within 3 years. That was the question. As far as claim for recovery, as a claim, I think that still that whatever period of limitation which is available in your common law or the specific provisions of Limitation Act, like the cases of acknowledgement of debt, like the cases of execution of documents, reviving the transactions or reviving the debt and confirmation of balances, all those things will be available for the claims to be filed.
It says, what is the role of adjudication authority before RP?
Role of adjudicating authority with regard to resolution plan. Probably the question is on regard to resolution plan. What Supreme Court ultimately had said is that in 2 judgments, one is that Sashidhar judgment versus IOB as well as in SR Steels, the commercial wisdom of the COC will be a deciding factor. In their commercial wisdom, if they decide that the resolution plan is viable for the corporate debtor and therefore if it is approved, the adjudicating authority is required to look into the requirements of the statute, whether the plan or the approval of the plan is in terms of the statutory provisions. The Supreme Court clearly says that the adjudicating authority cannot travel beyond that and try to substitute their commercial wisdom or try to substitute their views. They are required to see whether Section 31 stipulates and what the regulation stipulates as to contents of the resolution plan and how the implementation of the resolution plan, all those things has to be taken care. So today, the role of an adjudicating authority in terms of approval of the resolution plan is as regarding the compliance of the statutory provisions, and they cannot extend their limits as regarding interfering with the commercial decision of the commercial wisdom of the COC.
Vikasji, can I go next?
Yes, Srikanth.
Sir, a very lucid presentation. I couldn't switch on my video the other day. This is me. With regard to, I have more of a comment rather than a question.
Yeah, welcome.
Now, with the increase of the threshold from 1 lakh to 1 crore, what you as in the legislature has effectively done is ensuring the banks or the financial institutions to always secure the lending that they do. Otherwise, they cannot move under IBC. They have a very wide power under SURFACI. So what this has done is this has actually been a devil in the God's disguise, which has actually come to the MSME. This is my view. I don't know if you will agree with this particular view. Second is, with the exclusion of subsidiaries from what we discussed the previous session, now more and more shell companies I envisage a situation where shell companies will be created in multiple jurisdictions where it could not be touched by RPs. Now, with the resolution plans which are being approved, which is now standing at 53% as compared to 23% earlier, people are getting smarter.
Correct.
So these are my two submissions to you. So which is what is happening in the ground reality as such. But my question to you would primarily
just adding
be
to what you said is really it's a correct thought process also. But one thing is that probably this should lead to a situation of strengthening or bringing in a situation relating to group insolvency. There are many cases where you find a holding company doing very well, a subsidiary being put to CIRP, or holding company being put to CIRP, but you find a lot of subsidiaries which are in fact thriving like anything. And if there is an effective RP, in fact, you can find out ways and means where you can pull in these things. So there are instances where applications are filed as regarding recoveries to be made, and instances where you will find there is lot of funds which are flown from here to there and there to here, all these things, which will not be in fact related to the business activity at all. So this should now strengthen a system for group insolvency. If we can work on what probably I think there is already a thought process which is going on. The committee must be examining those issues. So once this group insolvency comes into place, this issue can be addressed in a better manner.
I'm actually addressing this with the Niti Aayog in this particular matter. So which is but one more comment which I would like to place is that yes, RPs are not feeling empowered in the current regime, because there's a lot of adjudicating authorities. Every time there is it's like a child. Another child has hit that particular child. They go and complain to a mother. Like that, NCLT is now being bothered. So that is a comment. Now my question, I'll come to the real question without wasting the time of the audience as well as you. The question is, when the IBBI itself can when there is IBBI, when there is adjudicating authority, when there is NCLT, NCLAT, and then Supreme Court, all these, the civil court can't even touch it. What is the need for another insolvency professional agency to actually administer what I'm a member of one of these institutions. I don't want to name it, but being a member, I don't see a reason. I don't know if I'm going to be, disciplinary proceedings will be initiated just because I've said this, but I don't see a reason for them to exist. What are your thoughts about this?
No, two things you can just think about it. One is that, as you rightly said about this disciplinary action. So today, when the code gets rolling and you get more of professionals working out, and instead of professionalism, somewhere you face these situations of various dubious things are happening. And if all these disciplinary proceedings are to be taken up only to IBBI, probably my thought process is that the reason for agency creation is that as agencies, they may know the specialization of that field. So they will be able to handle those professionals. Instead of the IBB finding its own disciplinary committees having different. See, there are 4 categories of resolution insolvency professionals: chartered accountants, company secretaries, advocates. Take the case of advocates. If there has to be something as a disciplinary proceedings to be proceeded against advocates, and if IBB has to get into it, there is so many things which will definitely come up for consideration. So leaving it to that for a different body is maybe one thought which is there. And secondly is that this knowledge sharing system. This is as far as Insolvency and Bankruptcy Code and the creation of IBB itself is that something which is very new to us and something which is in a vast area, vast field which is being developed. So in that, they are looking at knowledge sharing. I find these agencies, in fact, effectively are today helping out their members in this knowledge sharing. So those 2 areas which I am looking at a positive thing. But as you said, over the period of time, what wins over other is the different issue.
Dr. Sirikant,
yes.
No, I'm unmuting. Okay, Dr. Sirikant is through.
No, so, I have finished. I mean, it was just a thought which I wanted to place with because it was such a lucid presentation. And I feel coming from the RP community, they are hesitant, for a lack of a better word, because every action of theirs is going to be questioned, and it is going to be pulled. I mean, the litigation is going to happen against a specific RP. So there's a particular term called playing to the gallery. I think that is what RPs are doing right now, which is an unfortunate state of affairs.
In fact, one more thing which I got reminded is that as Srikanth spoke to me, which I missed out, the part of amendment which I have to point out to the gathering is that the latest amendment requires that as and when a petition is filed before the NCLT for initiation of CIRP, a copy has to be filed with the IBBA. Now, earlier, you have to serve a copy to the corporate debtor and then file it before the NCLT. Today, along with the corporate debtor, you also have to file it with the IBBA. They have provided a platform for that. So every application today gets also registered with IBBA. Maybe we don't know what is the thought process behind is that. But after a period of time, they will have enough of their information or collating the details, data.
Om sir, I don't know a single RP of the hundreds of RPs that I've met. I haven't met a happy RP as of late.
Before we take the next question, I'm just reminded, any businessman, if you ask, they will say that it's a dull season, and you will find that he's bought 3 showrooms nearby. And whenever you will ask, he will say that you can do anything but don't do business. This is by Abhishek Sharma. What resolution applicant is eligible? When a resolution applicant is eligible under section 29A, then what are the circumstances to stop COC to approve plan?
There is absolutely no situation to stop. In fact, Supreme Court in one of the judgment has made it very, very clear, saying that if you have an issue as regarding this eligibility or ineligibility or anything process of the approval of resolution plan, post the decision of the COC, when it comes up before the NCLT in an application under section 31, all you have to do is only go and agitate there. Prior to that, there is no question of stopping the COC. Provision doesn't provide, as well as Supreme Court has made it very clear on that.
Yeah. We will part for the day. First, I will ask Johnny Palvi ma'am ko unmute karo. And to all those participants, we have had number of tie-ups with the Gemtech College. And tomorrow we will again have one session with the college. And as a lawyers, we felt that if one could learn during the law time, once you're studying, then the best thing is we should also know how one has to research, how one has to analyze, and how one has to do the writing skills and written submissions. And therefore, tomorrow's session's topic, deliberately, we have kept it as raw, because students are normally raw in the knowledge of law. And therefore, the topic is raw means first, according to us, would be research, A is analysis, and W is written submissions and written arguments. So do stay connected with us. And tomorrow we have 4 times Advocate General of Karnataka, Mr. Uday Hola. And again, this session would be in tie-up with the Gemtech College. And thank you, sir, for all your knowledge. And before we part for the day, I request Ma'am Palvi Gupta, the HOD, to share her insights of the second session. And sir, since we are having the third session on this aspect, I will also request you to share date we will announce and ma'am will also announce on her group subsequently and on the social media. On what topic, what would be the third session delve upon, what people have to look upon on the third session on this master series?
The third session will be on individual insolvency. Though it is not notified as it is, what is the process which the code looks at? I'll be able to put it across to the members as to what is the process in an individual insolvency, because it is slightly different from the corporate insolvency resolution. In individual insolvency, you have different concepts which are coming up, like repayment plan to be coming from the individual. So all those things we will look at.
Over to you, ma'am.
Thank you, Vikasi. Thank you very much, sir. Om Prakash ji. for such a wonderful deliberation when the three cities are connected, Ketonada, Chandigarh and Madras, uh, for this common object to disseminate knowledge on a very technical topic, that is insolvency and bankruptcy code amendments. And you have in fact you have given the deliberation on the entire code, section 1 to section 24, 29, all the section are amended, and it is very difficult to for a person, for a student of law to come to know all the things all together. And in the meantime, students are asking that please tell sir to share the ppts and all. So because they are liking very much this thing, all things are in a one platform. So thank you very much, sir, for this. And definitely you have given this highlight the role of resolution professional. It's really very difficult to know by a student. In fact, they were asking whether, ma'am, please ask whether any qualification are fixed to appoint this resolution professional and all. Anyway, the things will come to know, and this is a session which is awareness program. It's the awareness program on the very technical issues. Thank you very much, sir, for joining hand. Over to Bikazi.
Thank you, everyone. And as ma'am said, I'm just reminded of a famous quote, as they say. In English, they say, well begun is half done. And sir has already shown us the better knowledge. And in Hindi, we say, आगाज अच्छा होगा तो अंजाम तो अपने आप ही अच्छा होगा. So thank you, everyone. Stay safe, stay blessed. And tomorrow we will connect.